On the record, cause number 327816, the state of Texas versus Jasmine Savoy. Ms. Savoy, would you please raise your right hand? Ms. Savoy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Ms. Savoy, you may put your hand down. How you doing, Ms. Savoy?
I'm okay.
That's good. Ms. Savoy, the information states that, or alleges that on or about September 19th of 2020, while you were in Jefferson County, Texas, that you committed the false misdemeanor offense of assault family violence. Do you understand what you've been charged with?
Yes, sir.
And to this charge, Ms. Savoy, how do you plead? Guilty, not guilty, or no contest?
No content.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Savoy, I have before me what has been marked as State's Exhibit 1 is the misdemeanor plea admonishment. On page 1 of this document, under punishment range, one box is checked. It states that this is a Class A misdemeanor, and the range of punishment is confinement in jail for a term not to exceed 1 year, a fine not to exceed $4,000, or both such fine and confinement. Do you understand the range of punishment?
Yes, sir.
On page 2 of this document, below the paragraph that is titled waivers, there's one box checked in nola contendere on the line next to that. There are some initials JS. Did you place your initials on this document?
Yes, sir.
Also, on the same page, in the next paragraph that is titled discovery admonishment, there are those same initials JS on a line that reads, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Are these your initials?
Yes, sir.
And did you place your initials on this document?
Yes, sir.
Mr. Boy, on page 3 of this document, above the line that says defendant, there's a signature that purports to be your signature. Is that your signature?
Yes, sir.
And on the next document, Mr. Boy, that document is titled Trial Court Certification of Defendant's Right of Appeal. There's a signature above the line that says defendant. Is that your signature?
Yes, sir.
There are two boxes that's checked at the top of this document. The first box states that this is a plea bargaining case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Now, prior to signing and initialing these documents, the court read you the judge's explanation of rights to defendants without an attorney. You were informed that you had two options. Number one, you may hire an attorney, or number two, if you did not have enough money to hire an attorney, you may request an attorney be appointed to represent you, or number three, you may represent yourself. Is that correct?
Yes, sir.
And after the court read you this explanation, you stated to the court that you wanted to waive your right to an attorney and to represent yourself. Is that correct?
Yes, sir.
And the court read to you the waiver of counsel that's located under the paragraph titled waivers in State's Exhibit Number 1, and you stated to the court after the court read you that waiver that was your desire. Is that correct?
Yes, sir.
Now, prior to signing and initialing these documents, did you have an opportunity to read the documents?
Yes, sir.
And did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, you like to offer State 1?
Yes, Your Honor, and I'd also like to offer State's Exhibit Number 2 as the probable cause affidavit for this case.
Ms. Savoy, the state is offering State's Exhibit Number 1 and State's Exhibit Number 2 as evidence to be used against you in this case. State's Exhibit number 1 is the document that have your initials on page 2 and your signature on page 3. State's Exhibit number 2 is the probable cause affidavit. We commonly refer to it as the police report. The state would like to use both of these documents as exhibits or as evidence against you in your case. Is it all right for the state to use these documents as evidence in your case?
Yes, sir.
No objection, State's Exhibit number 1 and State's Exhibit number 2 will be admitted. Mr. Roy, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay, Mr. Ward, please put your mask over your mouth and nose. Thank you. Mr. Ward, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
Yes, Your Honor. It's for 30 days credit for time served, tax and retire of the court cost.
Mr. Boyd, the state is offering that you serve 30 days in the Jefferson County Jail. However, you would not have to serve any more time in jail on this case because you've already served 30 days in jail. Therefore, you will be given credit for time served. Now, Mr. Boyd, the court cost in this case is $327. However, Mr. Boyd, you would not have to pay that court cost because the time that you have spent in jail has already paid it off. Therefore, the court cost will be taxed and retired. Mr. Boyd, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes, sir.
Mr. Boyd, I will follow the plea bargain agreement that you have entered into with the state. Mr. Boyd, I have to read to you a admonishment in this case because this is a family violence case. In accordance with the Texas Administrative Code Section 176.1, the court hereby admonish you of the following. You are, by entry of order or judgment, ineligible under Texas law to possess a firearm or ammunition. Beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Under Texas Penal Code Section 46.013, firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. B, firearm does not include a firearm that may have, as an integral part, a folding knife blade or other characteristics or weapons made illegal by Penal Code Chapter 46, and that is one, an or curio firearm manufactured before 1899, or two, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or center fire ammunition. The statutes listed below were a starting point for ineligibility. To possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure Article 42.0131, Notice of persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, Unlawful carrying weapons. Penal Code Section 46.04, Unlawful possession of firearms. Penal Code Section 25.07, violation of certain court orders for conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.026, warning on protective order. Ms. Savoy, you will be given a copy of this admonishment by the bailiff. Ms. Savoy, please follow the bailiff and have a blessed day.